You sued your doctor claiming that he was careless, causing you significant harm and injury, and now you believe you have a great case. Is it possible for the defense to call you up and to tell you, listen, we agree that the doctor was careless, and we also agree that his carelessness caused you harm and injury? Is that possible? You want to know the answer? Come join me on this beautiful walk through the neighborhood as I explain to you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is yes, that can happen. It does not happen very often, but it can happen. So here's the scenario. You believe that your doctor was careless and that his carelessness caused you harm and injury, right? So you sued him for medical malpractice. And the only way you can do that in New York is if you have a qualified medical expert review all of your records who confirms that you do in fact have a valid basis for a case. All right, so now let's say you've done that. Shortly after starting your lawsuit, your attorney gets a call from the defense lawyer, the attorney who represents the doctor whom you have sued. And what does that conversation entail? The defense lawyer tells your lawyer, listen, we've evaluated this case, we've reviewed the records, and we agree that the doctor was careless and violated the basic standards of medical care. We also agree that his carelessness was a cause of your injury. Now, that's great news for you. Totally great news, especially coming at the beginning of your lawsuit. Why is that? Because in these types of medical malpractice lawsuits, we have to show three things. The first thing we have to show is, number one, that the doctor violated the basic standards of medical care, that he was careless. That's known as liability. We have to show that his carelessness was a cause of your injury. We call that causation. And then we have to show that your injuries are significant and or permanent. All three of those things have to be confirmed by a doctor who has either treated you or reviewed all of your records. All right, so in this particular scenario, what happened? What happened is that the defense recognizes they have absolutely no defense, and now they are actually admitting that the doctor was careless. They are admitting that his carelessness caused you harm and injury. But here's what they are not admitting. They are not admitting the value of your injuries. They are not agreeing to the value of your injuries. So what does that mean for you in your case? Well, I'll tell you what it means. It means this has now short-circuited the entire litigation process, and that's a good thing for you. Because now you no longer need to prove liability. You no longer need to prove causation. The only thing you need to show is that your injuries are in fact significant and or permanent. That's what you need to do at this point. So now you don't have to go through the whole process of trying to establish that the doctor was careless. You don't have to go through the whole process of showing that the doctor's carelessness caused you harm and injury. Why? The fact that the doctor has now admitted those first two things is terrific, because now the only thing you need to focus on is your injuries. All right, so how do you do that? What you do now is you try and negotiate with the defense. Your attorney will go back to the defense, say, listen, we believe that your injuries are worth X number of dollars. The defense turns around and says, wait a second, there's no possible way your case is worth X dollars. We believe it's worth Y dollars. And of course, they're going to lowball any amount of money that you think your case is worth. And now you get into the negotiations. What happens, though, if you can't negotiate the case and you can't reach an agreement? Well, one option is to agree to go to mediation. And that's a private settlement discussion between the attorneys, the parties to the litigation, and an impartial mediator, typically a retired judge. Sometimes that mediation will help the parties reach an agreement on the value of your injury so that now you can settle your case. But there are instances where mediation will not resolve your case because the parties are too far apart. The litigants are too far apart, and they still think that your injuries are not worth what you claim they are. So what happens then? All right, now you have a trial. And you're thinking, wait a second, you expected to go to trial to show that your doctor was careless and to show that his carelessness caused you harm and injury. Why do you need a trial now since they've admitted those two things? Because you need a trial on damages to determine the true extent of your injuries. Now you will go ahead and have 6 members of the community, a jury, decide what your injuries really are worth. Now you'll have testimony from your treating doctors. You'll have testimony from various medical experts come in and explain to the jury exactly why your injuries are significant. And now you'll be able to tell the jury exactly what you can and cannot do, and do with difficulty and do with pain. And then the jury will have to evaluate and assess how much money to give you, because that's the only purpose for a trial on damages. The jury will be told that the doctor has admitted he was careless and that he's admitted that his carelessness caused you harm. So the only thing that the jury is now being tasked to do is to decide how much money you are to receive for the various elements of damages that you're claiming in the case, including pain and the suffering you endured from the time of the malpractice up until the time of trial, for the pain and the suffering that you have endured from the current time into the foreseeable future for the remainder of your life. All of those things the jury will be asked to evaluate, and they will ultimately come to a decision about how much money you are to receive. So why do I share this great information with you? I share it with you just to give you a sense of what really happens in these medical malpractice cases here in New York. You know, I do realize you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.